We have talked in this course about sexual and gender-based violence and crimes committed against children. So breaches of humanitarian law, violations of human rights, crimes against humanity or genocide being committed. These are not only punctual, occasional occurrences. They are the evidence of the structural imbalances existing in a state, in a society. So the criminal law dimensions must be related to a broader situation of human rights neglect and violation.
Societies that experience long-lasting situation of inequality or ethnic or cultural divide, or maybe most of all gender discrimination, are prone to fall into patterns of organized violence and conflict.
So to respect, protect and fulfill human rights is the best way of preventing also mass atrocities and international crimes. International crimes are not just opportunistic behavior of single individuals. They are choices, they are political choices organized at the political level in a society. Perpetrators reproduce patterns of behavior that the members of the community has practiced and tolerated and maybe hidden for generations in the society. So they are not the occurrence of a single event. They are patterns of situations of discrimination, violence, neglect, and so on.
So what we would like to stress during this week is the link between the occurrences of human rights violation, for which states are the respondents, and the commission of crimes against humanity, war crimes, genocide or aggression wars.
So based on this link between human rights violations and international crimes, we may say that human rights courts and human rights monitoring bodies operating at various levels, at the level of the UN or in the Council of Europe, the African Union, the OSCE, the Organization of American States, and so on, can contribute very importantly to the prevention of international crimes and to deter individuals to commit such crimes, operating on the level of responsibility, liability of states, international responsibility of states. So the two things, support each other: the work of criminal courts and the work of human rights courts. This work of monitoring and preventing human rights violations is done not only by international organizations or state-based organizations, but also by non-governmental organizations. Most of the work done in this connection is done by actually non-governmental organizations that collect information, put victims in contact with the international bodies, and in so doing support the practice that we are talking about.
During week 2 and week 3, we talked about the violation of women rights and the rights of the child in context of conflict or widespread and systematic attack on population. But systematic disrespect of the rights of these specific groups can be tackled by international litigation and reporting procedures. Such mechanism can put in the light the systematic inequalities that determine this violation and that are so embedded in societies. So embedded in societies that only an external actor can help to detect them. So human rights monitoring can indeed prevent the commission of crimes and atrocities during conflict and also in post-conflict situation and transitional regimes.
Regional courts, the European Court of Human Rights, the Inter-American Court of Human Rights, the African Court of Human and People's Rights have many times adjudicated cases in which people were violated their right to life, personal freedom, right not to be tortured, fair trial, and so on, in situations of pre-conflict or during a conflict, an armed conflict, or a situation of mass, unrest, social unrest, or in the aftermath of these conflicts, showing that this link between states' responsibility for, tackling situations of, imbalance, injustices, and so on, and the commission of criminal violations of international crimes is, something that can be, addressed by these human rights institutions. So these litigations have been of great importance in, prompting a response at the international and also local level to these crimes, international crimes being committed, and to complement sometimes the work of these international criminal bodies.
There is a potential and actual discrepancy between declaration and pledges at all levels to value and honor human rights on one end, especially for the victims of organized violence and conflicts. But on the other end, we have relatively poor outcomes coming from international criminal courts in terms of conviction, sentences, and reparations being paid.
We have seen in the past weeks the role of the ICC in addressing these kind of crimes. We have also to remind that the ICTY and the ICTR, the ad hoc tribunals, have been incredibly important in proving that actually you can, prosecute these crimes committed against women, against children. It is possible to prove the responsibility of individuals in this context. So it's no longer, admissible to neglect this kind of occurrences in wartime or in situations of disturbance. These have been also major contributions to the cause of human rights, not only of international criminal law.
However, the risk is that this progress can be ephemeral or just cosmetic if it fails to prompt as follow-up deep normative reforms and real changes in the social and political background of affected societies. Structural discriminations, for example, deeply rooted gendered inequalities, are among the causes of organized political violence and therefore international crimes. Most of the times, inequalities survive the conflict, especially when reconstruction and reconciliation processes do not give priority to human rights and the rights of the victims.
The link between the long-run work of international human rights courts and the punctual activities of international criminal courts that deal with the responsibility of individuals, while the previous one deal with the responsibility of states. This will be the object, the content of this week. We will provide you with some examples of interplay between these two dimensions, quoting not only courts actually, but also the outcome of some monitoring bodies that do not issue judgments, but views or recommendations to states. These are all part of this interplay, as I said, that can contribute to preventing crimes, operating on rights, and promoting rights, tackling the crime.